The most common contractual mistakes, episode 2, choosing the wrong jurisdiction, part of the series, Global Business Law in 20 Minutes with Federico Vasoli. Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hi everyone, Mac Pierre-Louis here, attorney mediator and arbitrator working through Texas and Florida.
And Natalia, advocate, mediator, and arbitrator based in Warsaw, Poland.
And Federico Vasoli, Italian lawyer, managing partner of the MTV Global with offices in Singapore, Malta, and Vietnam. It's great to be back.
Thank you so much. So in episode 1 with Federico Vasoli, we already covered the necessity of having a valid contract and why it is important that it is valid, that it is enforceable, and what actually constitutes such a contract. Today, we are trying to explain another important topic in the international business, which is jurisdiction, which actually is where do you can place your legal action if you need one. And having said that, Federico, agreements serve in many cases when there is a dispute. Should I try and opt for jurisdiction in my home country? Is it what you would advise doing it in the whole home country or elsewhere? And why and how people should opt for it?
They should and they should not. My rule of thumb is follow the money. That is, if you are likely to get sued, then you may want to make things a bit more difficult for your counterparty and not have your place of jurisdiction in your agreement. If you're likely to sue, perhaps it makes sense to use the counterparty's place of jurisdiction. That is just a rule of thumb. It does not constitute legal advice. Every case is different. Every case is different. I repeat it. And let me repeat the essential point that we stated last time, which is we need to have a valid and enforceable agreement in the first place, because that is the instrument through which we determine what jurisdiction we apply. So home jurisdiction has a very valid plus, which is you kind of know it. Perhaps if you've been in business for many years, if you're a business person, if you are the manager of a company, perhaps you've already been in court to represent your company or as a witness. So you're kind of familiar, you know what a court is, maybe you know, you see some familiar faces, and it sounds good to go home, to play in your home field when you have a legal dispute. However, it is not necessarily the most effective way to seek justice. First of all, going to court is not necessarily the most effective method to seek justice. Mediation, arbitration, other forms of alternative dispute resolution can be more effective, can be quicker, can be administered by people who are specialized in a certain field. In many jurisdictions, you don't find judges that are specialized in a specific field. So they may be geniuses at law, no question about it. Well, maybe they're not. Maybe they are, sorry. But maybe they don't understand your business. They don't understand your industry. Whilst if you choose a specific arbitration center, maybe you can find the right people, the right arbitrators, for instance, that understand your business. So that may be a very valid plus to choose an alternative dispute resolution forum, in this case, that is different from your home jurisdiction.
Thank you for that. So let's say you choose the quote unquote right jurisdiction. Are there still other common obstacles that you could still face?
Yes, of course. There are formal obstacles. So you can elect a certain jurisdiction, but then the contract is not properly drafted. You can decide to Okay, I'll give you an example. Recently, we had a case in Vietnam of a client of ours from Europe that had a contract in place, but the jurisdiction clause was very poorly drafted. It said that in case of dispute, the parties would go to the Vietnam International Arbitration Center, which is one of the most famous arbitration centers in Vietnam, at least, and perhaps in Southeast Asia. But it did not specify anything else. It didn't specify the number of arbitrators. It didn't specify the venue. So yes, in certain cases, you apply the rules of the arbitration center that would step in case you didn't write a proper arbitration clause. And so the default rule would be, I'm just inventing, 1 arbitrator, 3 arbitrators, venue is where the registered address of this arbitration center is, etc. But what if this is not the case? What if the counterparty challenges the fact that the arbitration clause was not properly drafted because it lacked certain essential elements, and because if you go to the website of this or any other arbitration center, usually you have a standard clause which was not copy-pasted in this case. So that was already a challenge because we immediately envisaged that the counterparty would challenge the fact that we'll go for arbitration. They would go to an ordinary court of justice, and they would say, hey, we've been called to go for arbitration, but we dispute this choice, and we don't think that this venue is valid under a contractual standpoint because the clause was not properly drafted. So first, we want the judge to determine that the place of jurisdiction is correct, and then we will see. Now, this is a particularly complicated case, but there can be some others where you perhaps choose the right place of jurisdiction, but then you don't receive justice, even if you win the case. Suppose you have it happened to us again. You go to court in Italy in this case, you get an injunction from the judge that orders your counterparty on the other end of the world to pay. What do you do with that? You need to enforce it. You need to go to the right jurisdiction again in the counterparty's country and have your sentence enforced by the local judges. And that is where alternative dispute resolution can help a lot. If you go for arbitration, you have the New York Convention on the mutual recognition of arbitral awards. If you go for mediation or other types of arbitration, domestic arbitration, then of course it's easier because it is exactly in that same place where the counterparty is. So you may choose the right jurisdiction, but then do not receive justice because you're not able to enforce that sentence in your favor. And so it is being a total waste to go to court, even to hear a judge say, yes, you're right, this is your sentence, go and apply it. How do you do it? How do you enforce it? So there are still obstacles, yes, indeed.
Thank you for that. And let me also bring up some other issues. We already mentioned that the court proceedings can be quite lengthy, and that can be an obstacle. However, do you think that in case of the, let us say, arbitration clause being invalid or mediation clause being invalid, there is still a way and there should still be an opportunity for the parties to validate it by going to a court and then finding a jurisdiction? And how would you then try to figure out how this jurisdiction should work in a particular case?
Absolutely. So in the first place, I would have, again, let me reiterate the importance of having a valid and enforceable contract between the parties that is simple and clear to read, and that a third party that is not familiar with the case and with the parties, and the contractual parties, such as a judge or a mediator, will sort of easily understand. Then be tidy in how you conduct your business. Collect all the pieces of evidence. Make sure you have everything, because what happens is that people in companies change. They move from one company to the other. Computer servers get lost. You have missing pieces of information, have missing data, and eventually when you need them the most, that is when you go to court, you have to retrieve all that. So back to episode 1, make sure you have a simple, valid, applicable, enforceable agreement in place. And make sure that agreement does contain a governing law and jurisdiction clause. Then yes, going to court can be a very lengthy exercise, a very painful one. It can be also quite expensive. You may win the case ultimately, but then you don't receive justice because you win the case maybe 10 years later, after maybe an appeal and even a second appeal to the Supreme Court or to whatever other body you may have up there. So what do you get? Maybe you win and your counterparty in the meantime has gone bust. They don't have any assets to attack. They change line of business. They have disappeared. They have vanished in thin air. So I would recommend, again, choosing a faster path, which could be, for instance, mediation or arbitration. Try and settle things. In fact, this is a trend almost worldwide, because you do see legislators trying to push for these alternative forms of dispute resolution, sometimes by making them compulsory. In Italy, for instance, in most civil cases, you need to demonstrate to the court that you have attempted to settle the matter of court. It is also a way to reduce the burden of cases that courts have to face, because there are so many old cases still pending that they need to digest all this legal mess that was created in the past. So yes, justice can be long, and I would recommend choosing a venue that is okay for everybody and that can serve justice in a quick and effective manner, like arbitration or mediation.
Thank you. So when we speak about uh, choosing a venue, before we go to the next question, what about the situations where the two parties don't see eye to eye on where the where the forum court should be that will handle any potential disputes? Can you comment on that a little bit? I'm pretty sure that comes up quite a bit.
Yes, it does. In fact, again, it is a matter of everyday people not being familiar with these instruments. So typically you would have one, especially when you negotiate the contract, you would have one party that says, I am based in Poland and I am okay with arbitration, but I want arbitration to take place in Poland. And the other one is in Italy or in Malta and says, no, we're a Maltese company. Why do we have to go all the way to Poland for arbitration? We're okay with arbitration, but let's have arbitration in Malta. And they don't understand that sometimes you can use the same arbitral center that has different venues, different locations, but it is the same body that administers arbitration. So it is a matter of knowledge, really, and of involving lawyers that are familiar with these cases. And say, yeah, you know what, we can choose this arbitral center that happens to have a seat in Poland and another seat in Malta or wherever else, or perhaps even if they don't have their own offices in these two countries or any other country for that matter, you can still choose your own private venue and still seek for arbitration or mediation from the same arbitration center. So you can say, yes, we choose ABC as our arbitral center, and the place of arbitration will be online. Wow, magical. Or it will be Milan, or it will be Singapore, where this arbitration center doesn't even have an office, because there is a lawyer there that has an office, or there is a meeting room or whatever, and you can have justice served there. So that is a solution. And sometimes the other aspect that is not taken into consideration by everyday people, businesses that are not familiar with these instruments, is that, okay, we should choose a very famous, a very prestigious arbitration center, which may be a good solution if they have specialized sections. So they have a section that is specialized in IT law. Okay, brilliant. They can solve a dispute if there is. We talked a while ago with Thomas about non-fungible tokens and potential disputes over cryptocurrencies and blockchains. Okay, if you have in this case, a mediator or an arbitrator that is specialized in this field, then you have a section of the arbitral center that is specialized in this, fantastic. But you don't necessarily need to go to a super famous arbitration center. You can choose whatever you want as long as the matter can be subject to arbitration according to the governing law of the agreement. So again, pay attention to what the governing law is. Make sure that the agreement is drafted according to the law that you decide to apply. Make sure that it does not go against imperative norms. And then you can choose virtually anywhere as a place of jurisdiction.
So I'll follow up on that. So you're saying that arbitration, you don't necessarily have to pick the most expensive place, just go to a place. What other tips then can you give on arbitration in general?
Not at all. So the tips that I can give are: choose carefully. Don't choose on the basis of the image and reputation of an arbitral center. That is, you don't have to, I don't want to mention names here, but you don't need to go to big international venues for arbitration because they may be too expensive. They're simply leveraging other brand name, but they don't necessarily offer a better quality service. I'm not saying they're not offering a good quality service, mind you, but the things that I would consider are, first of all, if the matter can be adjudicated by an arbitral tribunal or whatever other alternative form of resolution, because there are some matters that cannot be submitted for arbitration or mediation. So first of all, check that. And how do you check that? You check with your lawyer or with a lawyer that knows the matter and knows what law you're applying. So that's the number one issue. Once we've cleared that we can go for arbitration, mediation, or any other alternative form of dispute resolution, then I would choose a place, an arbitral center that speaks the language that we apply to the contract. Is it always English? Is it Polish? Is it Vietnamese? Is it another language? What the arbitrators are, who qualifies as an arbitrator or a mediator in that center? Is it anybody that can apply and just be there, be picked? Could it be? Do you need to be a lawyer or a former judge to have this role in this arbitration center? Do you need to have a technical specialization in a specific industry? Does this arbitration center have, as we mentioned earlier, specific sections that are industry based, technology, whatever else, cosmetics, you name it? And then how fast is the arbitral award generally administered? There are some arbitration centers that guarantee that an award will be given within 9 months. So that is pretty good. And it happens to me a lot of times with clients that choose arbitration to scrap the arbitral tribunal chosen by their contractual counterparties and say, no, let's choose this one because this one is faster and they know your industry much better than the one that the others had chosen. And it is not necessarily that expensive.
Thank you so much. You've already covered some of the aspects of how arbitration can be beneficial. How do you also have some warnings to people very briefly before we close out about arbitration and what to really, whether it can be detrimental going through the arbitration clause in the contract?
It can be detrimental if the arbitration clause is not properly drafted. In essence, you have to have a validly drafted, a valid clause that contains all the essential matters. So venue, by venue I mean what arbitral center you're choosing, or if it is a private arbitration center, who the arbitrators are, language of arbitration, whether the arbitration award can be appealed or not. Usually it is not, usually it is final. If there is a cap to expenses, and sometimes you can even choose 2 arbitration centers depending on the value and on the type of matter that is subject to adjudication. It happened to me several times, for instance, in Vietnam with Vietnamese clients or foreign clients that do business in Vietnam. We have an arbitration clause that covers up to a certain amount of money that is considered relatively low for the client that is submitted for adjudication in Vietnam. And above the threshold, we go for arbitration in Singapore. That is also an interesting tool because we think that one is more specialized, is good for these things, and another seat is good or better for other matters of a higher monetary importance.
Having said that, I would want to thank you, Federico, thank you, Mark, for this piece of interesting discussion. I think that we will focus on arbitration and mediation and the particular clauses in further episodes of this series. But for now, I would like to close. I thank you, the viewers and the listeners, for being with us. I hope you find it interesting and stay with us for the next episodes. See you soon. Bye.